I'm having a mental just overload. After 5 years of Sarah Boone and a swift verdict, she's ready for a new trial, and we're going to talk about that motion in today's video. Hello, Sofa Squad, and welcome back to the sofa. Y'all, we're finally back at the sofa, okay? I mean, this is major. Hello, Rosco. How you been? I mean, come on now. My name's Paul if you're new to the channel. If you're not new to the channel, my name's Paul as well. And welcome back to the sofa. So I've been traveling, getting stuff done, so we're back here at the official Sofa Squad. Now, y'all, you already know, we've been following the Sarah Boone trial for years now. She was convicted. We're waiting sentencing, so we don't know that yet. I'm filming this on November 7th, 2024. Pause. I'm having a mental just overload. This is pretty standard protocol when people get convicted, they want a new trial, this and the other. We knew this was going to happen. She has filed a motion for a new trial. We're going to read through it in today's video. So I'm not shocked that she did this. Mind you, she was very quick about it. Let's just go ahead and be honest, but they do have deadlines to do this stuff. The reasonings are not shocking because we kind of saw this coming, but I'm very eager to see this whole process take place. I don't know if we can spiritually survive another Sarah Boone trial. It'd probably be 20 years in the making, right? So what we're going to do for this video is it's going to be kind of short. I'm going to put the motion up. We're going to read through it. We're going to talk about it. I will do a live chat and read through it and talk about like in person on my other channel. By the time you see this, that would have already happened. So just go and hop over there if you want to watch the live chat, okay? So let's go ahead and put that first thing on the screen and check it out. Okay, you're going to see the motion here. It says defendant's motion for a new trial. Comes now defendant Sarah Boone. Let's go ahead and jump now to number 1. She was found guilty second-degree murder October 25th, 2024. The instant motion is timely, filed pursuant to Rule 3.600. The defendant asserts, now this is the major thing here, so number 3. The defendant asserts that she is entitled to a new trial under Rule 3.600 on the following ground. I, the court erred in ruling that the defendant was not entitled to court-appointed counsel. I mean, we kind of saw that coming, right? The court erred in denying undersigned's counsel's multiple motions for continuance. That one I think is ridiculous, okay? But I digress. Number 3, the court erred in failing to grant a new trial when the alleged victim's family caused an emotional outburst in open court in the presence of the jury prior to deliberations. Now that one right there, do I got my damn cup with me? I've got the unintentional cup with me. That's a roll your damn eyes to the back of your head right there. Honestly, seriously, let's keep going. The trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Werner, MD, after the state failed to disclose before trial that the witness had formed a new opinion. Now, side note, y'all, they published her 87-page transcript. After I record this video, I'm recording a read-through of that, and we're going to do a live chat of that at like 9 o'clock tomorrow morning. Again, that would have already happened by the time you see this, but go check it out if you want to watch that live, or go on to the next video to watch the recording of it. Let's keep going. Number 5. The state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. Now you gotta admit that second one took them out. It took them out. I'd be pissed over that one too. I'd be pissed if I was Sarah's side over that one too. Y'all, that second time the state got up there, that was a nail in the coffin, right? So I'd be a little bit bitter over that too. I'm not gonna lie, okay? I get it, Sarah. I get it, Mr. Owens. Now let's go ahead and jump down to that next thing here. It says law and argument, argument 1, the trial erred in holding the defendant was not entitled to court-appointed counsel. I mean, my God, right? We knew this was going to happen. Okay, in the above styled and number case, the defendant had approximately 7 court-appointed attorneys prior to the undersigned counsel taking her case. I mean, just that first opening right there, it's like done, denied, move on. Okay, let's go to the next page. Counsel took on the above case because he was concerned that Ms. Boone would not have an attorney to represent her at trial. The above case was very complex, even for a seasoned trial attorney who was the public defender of the First Judicial Circuit for years, as well as having a thriving private practice. It was apparent to undersigned trial counsel that Ms. Boone would be grossly ill-prepared and unequipped to handle a trial in this matter, or in fact, to handle any other phase of the trial without counsel. Both the Sixth Amendment as well as Rule 3.111, Florida Rules of Criminal Procedure, guarantee an indigent defendant the right to appointed counsel. And then he just goes into a couple of things here. There appear to be 2 exceptions to this precedent. If the defendant physically harms or threatens to harm, our battery, etc., her counsel. If the trial court certifies that the defendant defendant will not be incarcerated if found guilty. A judge trial. Should the court determine that the defendant is not entitled to court-appointed counsel due to misbehavior on the part of the defendant, the court must follow a process which protects the individual's right to due process, as well as the defendant's right to the assistance of counsel. In the instant case, undersigned trial counsel would assert that Ms. Boone's behavior did not rise to the level of misconduct to warrant a waiver of the right to court-appointed counsel. And if the court determines that she waived her right to court-appointed counsel, then the court failed to warn her or inform her that continued misbehavior would result in a waiver of the right to court-appointed counsel. Under controlling precedents, the failure of the court to appoint trial counsel can result in a motion for a new trial guaranteed. And then it just goes into the little case law and whatnot. Now let's go into argument 2 here at the bottom. It says the court erred in failing to grant defendant's motion for continuance made by undersigned trial counsel. The court shall not deprive a defendant of his or her right to counsel of their own choice. Failure of the trial court to grant a continuance will result in a new trial should the court deny said motion for continuance by new counsel. And he cites some case law there. Let's move on to the next page. In the instant case, when undersigned counsel came on board, the case was 4 years old. Undersigned counsel filed his notice of appearance on August 30th. This gave counsel 45 days to prepare for a second-degree murder trial. He immediately and aggressively began to prepare for trial. Undersigned counsel did his best to prepare for trial by traveling to Orlando from Milton on multiple occasions, both for meeting with Ms. Boone and attending multiple hearings. Despite his best attempts to prepare for trial, it was impossible to adequately prepare for unforeseen issues arising during trial. A prime example of this would be reviewing hundreds of pages of text from Ms. Boone's seized cell phone, viewing all records of prior contact of Ms. Boone and the alleged victim with law enforcement, including inadmissible hearsay by the alleged victim to law enforcement regarding Ms. Boone being the aggressor at times. Counsel, for all purposes, closed his law practice down to prepare for the trial, but due to short time frame, even with the assistance of other attorneys, was simply logistically unable to be as prepared for trial as he would have liked to be, and as Ms. Boone was entitled to. Under the controlling cases cited supra, the court's failure to grant undersigned counsel's motions for continuance should result in a new trial. Now, again, if I didn't say this at the beginning, if you're new to the channel, keep this in mind. I'm not a lawyer, I'm not a doctor, I'm not a cop, I'm not an investigator, I'm not any of that fancy credentialed stuff, okay? Only credentials we got is a sofa, some sass, and some self-diagnosed personality disorders on my part. Okay, so that being said, this right here, I'm just like, the court made it very clear she was abusing the legal system. That's why he took her thing away. Her attorney made her go pro se. Secondly, that was never going to be an excuse. He made that very clear. So him coming at the last minute talking about, well, we need this, we need that, it was just going to get dragged out for years more, right? I think one thing that she was wanting to do was just drag this out to get a plea deal eventually of, I don't know if she wanted not guilty. I don't know really what she wanted. I mean, obviously we know by the reaction that she thought she was not guilty. But, you know, and again, I understand his part where it's like, well, you need to prepare for trial. But dude, you knew what you were getting into. It wasn't like this was just a brand new case that he got and went to, you know, court a month later, okay? That's not how that works. Okay. Anyways, let's go on down to number 3. Okay, so argument 3. The court erred when it denied a motion for new trial due to an emotional outburst in the presence of the jury. Prior to jury deliberations, the alleged victim's family members began to audibly and visibly get upset and departed the courtroom. Undersigned counsel timely moved for a mistrial. Requesting a new trial, the court did not give any curative instructions or address whether the outburst could adversely affect the jury's deliberations. Florida appellate courts have held that the failure of the court to grant a curative instruction or a mistrial can result in the necessity of granting a new trial. Case law, and then skip down. The court is unable to determine if this outburst affected the jury's decision because no inquiry was made. Under controlling precedents, the defendant is entitled to a new trial. Now, on this right here, yes, there was an outburst. Yes, and we don't need that happening in the courtroom. I get from the emotional standpoint, like I can respect that on the family's part. Yeah, the judge probably should have said something, you know, about like, hey, is this going to affect you, this, that, the other. I get it. It would be really sucky if a new trial was granted over that, right? I mean, that would not be good. Okay, let's go on to number 4 argument. So the court erred in allowing the opinion of the state's expert not previously disclosed. The trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Werner, MD, after the state failed to disclose before trial that the witness had formed a new opinion relating to whether the defendant perceived an imminent threat at the time of the offense. The issue was discussed extensively exhaustively in the expert witness's deposition taken on October 4th, 2024. The state committed prosecutorial misconduct by failing to disclose this new opinion as agreed in the deposition mentioned above. In addition, the state's expert opinion on whether the defendant perceived an imminent threat necessary for the justifiable use of force and battered spouse syndrome testified to before the jury was improper. The state's expert, Dr. Tanya Werner, MD, admitted she had not listened to the defendant's testimony before the jury before forming her opinion on this ultimate issue of fact. In addition, Dr. Werner failed to listen to the testimony of Dr. Michael Brannon and Dr. Julie Harper before expressing her opinion. Furthermore, the state's expert testimony on this issue of whether the defendant perceived an imminent threat at the time of the event violates the province of the jury. Witnesses are prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury determine what occurred. And then it cites the case law here. When a witness is asked to express an opinion that applies a legal standard to a set of facts, the opinion testimony is generally inadmissible. Then it skips down there to say section 90.703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law. This testimony may interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon. And now we're going to go on to that last one, argument 5, last page. The prosecutor committed misconduct by rebuttal argument to make a second closing argument. The state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. Counsel for the state made a second closing argument posed as a rebuttal. And then it just goes into all the little stuff that we see. It signed James Owens at the bottom. So let's get into a few of my thoughts about this. Now, again, this is standard protocol to me. This is very normal. This is not a Sarah Boone thing. They, meaning defendants who have been found guilty of a crime, are going to immediately start filing for, mistrials and appeals and new trials, and this is just part of the process. I can assure you, we're going to hear from Sarah for a very long time, okay? On some way, shape, or form. Whatever happens at sentencing, I personally think she's going to get 30-some years. Why do I think that? I just think it's a middle ground between, life and 22. I think she'll get 30-something years, and that'll be that, and we will hear from her non-stop. Okay. Do I think some of these have validity? Well, on her side of the fence, of course they do, right? The lawyer is going to, meaning Mr. Owens, is going to find any reason to do whatever he can. These are little things that I'm sure when you're in the court and doing this, some things you might overlook or not think about. So, for example, the family runs out. Maybe he should have asked the jury and polled them. Is that going to bother you? Is this or that? Please don't take that into account. Whatever. Now, also, the state's expert, that one right there, I'm like, you saw how that went down if you watched the trial. She kind of allegedly changed her opinion. They did a deposition right then and there in the open court. It was very awkward. And also she said that Sarah did, yes, she agreed with the BSS, battered spouse syndrome thing. However, that didn't inform what was going on, essentially, is what I took from it and what was my opinion. If Sarah really did suffer from that, I personally also think that she probably did a lot of research on the subject, but I don't know. I'm not Sarah, right? So I can't say. So that being said, I'm curious to see what you think. Do you think this will go through? What do you think of the reasons listed? Let me know down in the comment section. If you are still watching, well, you know what? I thank you for doing so. I greatly appreciate it. And if you could drop some little sofas off in the comment section for myself, Rosco and Spirit, Bo and Luke, who are sleeping very nicely over there in the bed. And until we all meander down to the Sofa Squad comment section, I'll see y'all soon. I just wanted to say thank you again for watching the whole video, and also thank you for being part of the Sofa Squad. Special thanks to all the Patreon members, channel members from both of my channels, everybody who likes, shares, subscribes, comments in the comment sections. It helps the channel out so much. Now, don't forget, I do have that other channel, the podcast channel. That's where we go live, we hang out, we talk. We have kind of sort of a schedule, but just be sure and check it out. I'll put it up here on the screen. Also, if you're looking for merch, be sure to check out my Teespring store. I'll put that up here. And then, like I said in the beginning of the video, if you want to follow me and Rosco on the Instagram, go on, check it out. It's right here on the screen again. But once again, thank you very much. I really appreciate you being part of the Sofa Squad, and I'll see you in the next video.